As you can see, this is Lecture 2, Topic 2 in Administrative Law. We're looking at merits review and administrative appeal tribunals. In this case, focusing on the Commonwealth Administrative Tribunal, but in the first part of the lecture, we'll be looking at state-level tribunals like VCAT, NTCAT, SACAT, and so on. The CATs, as they're sometimes called, fairly unimaginatively. As you can see, the reading for this week is Crike and Macmillan Chapter 3, your head textbook Chapter 4, 2 additional reading articles by Macmillan and Crike themselves. You probably don't need to read them, but they do add something to the textbook itself. If you only read one, Peter Kane, the AAT as Trojan Horse, is a very good article, I think, that focuses on, as the title suggests, merits review and judicial review, and comparing and contrasting them and suggesting that perhaps they're not even quite as different as it's sometimes said. So that's the reading for this week. As the slide says here, defining a tribunal as opposed to a court is quite difficult. Some of them do operate like courts, in fact quite difficult to tell between them. The Commonwealth Administrative Appeals Tribunal is very much like that. It looks and feels like a court. It's laid out like a court. It usually applies the rules of evidence, even though it doesn't have to, and so on. Other administrative tribunals are much more like executive decision makers, because after all they are fulfilling an executive function. As your textbook says, tribunals' procedures and methods of dispute resolution vary widely. Some are like courts, while others have a close similarity to executive decision makers. Increasingly too, tribunals resolve disputes through discussion and negotiation rather than a formal decision. So in other words, almost invariably tribunals have greater emphasis on preliminary dispute resolution techniques like mediation and conciliation than courts do, although increasingly courts themselves are placing much greater reliance on mediation and conciliation as prerequisites to adversarial litigation. Largely under the influence of expanding lists, delays and costs and so on, courts are also, as I say, becoming less adversarial, at least at the initial stages, more favourable towards alternative dispute resolution mechanism. One response to this definitional uncertainty has been to describe tribunals as court-like bodies that are not courts. And I guess that's not too bad, although it doesn't really help us very much. And really the only way to help is to look in detail at what each individual tribunal does. What are its powers? What is its jurisdiction? What are its procedures and so on? You cannot assume that just because you know how things work in the AAT or just because you know how things work in VCAT, that it's necessarily going to be pretty much exactly like that in some other tribunal. It may not be. So there is no magical description of tribunal that will necessarily get you there and allow you to simply walk in and know exactly what you're doing and exactly how it operates. Nevertheless, there are common characteristics, as the slide says. There certainly has to be a measure of independence from the government department that the tribunal is reviewing, engaging in merits review. Secondly, at least historically, tribunals have been specialised, but that really is undermined by the fact that, of course, the AAT was the first of the generalist or general jurisdiction tribunals doing merits review under a wide range of acts of parliament federally. And the CATs, VCAT, NTCAT, SACAT, and so on, have adopted that approach as well, general jurisdiction tribunals. That having been said, typically, at least the larger CATs, especially VCAT and New South Wales CAT, they have divisions, so they are somewhat specialised within the CAT itself. So you'll find there's a building dispute division of VCAT and so on and so forth. So there is specialisation within the tribunal, even though the tribunal itself covers a wide variety of areas. Thirdly, they're effective. Well, effective in the sense that they do make decisions in very important areas, as it's put at the sharp end of the administrative process, and they do so in a hopefully a quick and efficient manner. They don't conduct litigation that goes on for years and years, which sometimes happens in state supreme courts. Their functions typically include making decisions that are sufficiently serious and specific in relation to the citizen as to attract the common law duty of procedural fairness. Of course, we'll be looking at procedural fairness or natural justice later in the semester, but you can assume that all of the CATs and the AAT are bound by the principles of natural justice or procedural fairness, and we'll be looking at the specifics of that in relation to the AAT a little bit later in this lecture. Now, tribunals in the system of government are, generally speaking, in the executive arm of government. That having been said, the CATs confuse that a little bit, because most, if not all, of the CATs have to some extent judicial functions, because they can at state level. There's not a constitutionally entrenched system of separation of powers, so it's possible for state parliaments to vest judicial powers in a tribunal. You can't do that at federal level because it would breach the separation of powers. So the CATs have both executive powers and functions and judicial powers and functions. Nevertheless, both they and the AAT are, in a very real sense, part of the executive, even though they fulfill quasi-judicial role. They, as I say, to varying extents, they look and feel and act like courts. There's a common theme. Tribunals are established to provide a method of dispute resolution characterised by speedy processes, minimal fees, reduced reliance on legal representation, and less formal procedures and evidentiary rules. Now, the extent of each of those things is a little bit questionable. Certainly they're speedier than Supreme Courts, not necessarily all that much speedier than, say, a local court or district or county court. Minimal fees, yes, certainly by comparison with Supreme Courts, where filing fees alone usually run into thousands of dollars, and costs are generally awarded to the winner, and those costs can be crippling, whereas typically in a CAT or the AAT, costs are not usually awarded, although they can be. They can be. So don't assume there's no costs in a tribunal, because there may be, and you really do need to warn your client about that. Reduced reliance on legal representation. Yes, indeed, there are some tribunals where legal representation is only available by leave, not as of right. However, typically legal representation is allowed. We'll talk about that perhaps a little bit later in the lecture. Less formal procedures and evidentiary rules. Yes, again, almost all of the CATs and the AAT have specific provisions saying that they're not bound by the rules of evidence. However, as we'll see a little bit later, at least in the AAT and to varying extents in most of the CATs, they do in fact apply the rules of evidence unless you can argue very powerfully that there's a very good reason to depart from them in a particular situation. So, you know, if you're going to be a lawyer acting in a matter in one of the general jurisdiction tribunals, you better damn well have a pretty good understanding of the rules of evidence, the Evidence Act and so on. Okay, we'll now go on and have a look at some of the particular CATs, if you will. Let's look in a preliminary sense, though, at the AAT, and we'll come back to the AAT in the second part of this lecture recording and look at the AAT in detail as the paradigm example of a general jurisdiction administrative tribunal. It was created by the AAT Act 1975, the first arm of the four-part so-called new administrative law package that was ushered in as a result of the Kerr and Bland committee's reports in the early 70s. You'll remember the other parts of the new administrative law package apart from the AAT were the Administrative Decisions Judicial Review Act, ushering in codified judicial review, the Ombudsman Act and the Freedom of Information Act. Now please make sure you memorise those because that's a very basic fact. What are the four parts of the so-called new administrative package? Even though it's no longer new, it's been around for 40 years or more, it's still to some extent referred to as that, and it's the starting point. The AAT's major areas of review: Social Security, Veterans Affairs, Taxation, Commonwealth Employees Compensation, that is workers' compensation, and Freedom of Information. The AAT also now has a significant area of jurisdiction that deals with migration matters, merits review of migration matters. That's a relatively new development. In the 1980s, the Commonwealth implemented a number of separate tribunals alongside the AAT, the Social Security Appeals Tribunal, the Veterans Review Board, the Refugee Review Tribunal, the Migration Review Tribunal. Now most of those, especially the Veterans one and the Social Security one, were so-called second-tier review, and I'll come back to that a little bit later, and there was an appeal from Social Security Appeals Tribunal or Veterans Review Board to the AAT. On the other hand, you had the Refugee Review Tribunal and Migration Review Tribunal, which existed alongside the AAT in the sense that if you were adversely affected by a decision to refuse you a protection visa, a refugee visa, or indeed some other sort of visa, then you were obliged to go to the Refugee Review Tribunal in the case of protection visas and the Migration Review Tribunal in respect of any other type of visa. And there was no appeal from there to the AAT. If you remained aggrieved after a hearing by the RRT or the MRT, your only avenue from there was appeal to the Federal Court. However, as the slide says, following numerous reviews, in 2015 the Commonwealth introduced a renewed amalgamated or general jurisdiction tribunal encompassing most areas of administrative review under the AAT's purview. So the AAT now does receive merits review in relation to both protection visas, other visas, Social Security, as well as, of course, tax and Commonwealth employees, workers' compensation, freedom of information, and so on. So a very broad-based tribunal. Here we focus on the fundamental fact that administrative tribunals have been set up to be independent of government. They're meant to be impartial, independent, make the correct and preferable decision on the merits so that citizens can achieve substantive justice in situations where they believe they've been unfairly treated by the government department or agency or minister who's been vested by Parliament with the substantive original power to make the decision. But there's a conundrum involved in that. Because the role of an administrative tribunal is like a government decision maker, it appraises the merits of an administrative decision and looks broadly at the legal, factual and policy issues. And it's expected to make the correct and preferable decision. Moreover, its decision usually substitutes for that of the original decision maker. And as I said, I think in the in topic 1, that does create a conundrum because, especially flowing from the constitutional doctrine of representative and responsible government. Governments are elected on a policy platform which they're expected to deliver, and if they don't deliver it, they may be voted out at the next election. So there's a problem potentially with an independent, impartial merits review tribunal consisting of unelected judges and other tribunal members that could potentially thwart the government's implementation of the policies and promises on which they've been elected to government, because the tribunal could say, well, we don't agree with that. The correct and preferable decision in this case is one which is contrary to the government's policy. So say that's a problem. There are 3 aspects to independence: membership, management, and government policy. And each of those potentially creates dilemmas. There's an obvious tension between independence and accountability and implementation of government policy. Now, there are some of the state CATs that have a procedure that allows the government to require a tribunal to implement government policy, whereas that's certainly not true in the AAT or for that matter in VCAT. They are completely independent and impartial, and their decisions do substitute for the decision of the government of the day, and it's not possible under their legislation for the government to direct the tribunal to implement government policy. So some of the CATs, as I say, and that includes NT-CAT, I might say, have implemented a system that gives the government the ability to compel the CATs to implement policy. So that's an interesting development, but not a universal one. Now, the situation with tenure and independence is that it varies between tribunals. Typically, the tenure of a tribunal member will be between 3 years and 7 years, depending on the tribunal you're looking at. However, sometimes it's been as low as 6 months. When we had the Refugee Review Tribunal, for instance, federally, there was at one point the government was appointing members for 6 months because they wanted to make sure the RRT was firmly under the thumb of the government and that it was as tough as they wanted it to be in refusing protection visas. This was back at the time when of the Tampa and subsequently arrival of lots of boat people and so on. But typically a tenure of between 3 years and 7 years. Now, of course, that's not as much as a Supreme Court or the High Court or Federal Court, where tenure is to the age of 70. So not quite as independent. There's some degree of pressure that you would hope they mostly resist to behave in the way that the government of the day might want them to. They can, however, generally speaking, only be dismissed for proven misconduct or incapacity and so on. So very similar in that way to the way in which judges can be gotten rid of, although judges can only be gotten rid of course, by Parliament, generally speaking, whereas that isn't usually the case with tribunal members. Qualifications of tribunals will again varies between tribunals. Typically they will have some requirement for legally qualified members. Not necessarily all members though have to be legally qualified, because there's necessary scope for expertise from some of the areas that the tribunal is expected to conduct merits review of, like areas of, planning and building and those sorts of things. There's a need for some expertise in that area. The role of legal members and the role of lay members, I'll leave you to read in 3.2.71 capital E. Now, the language of merits review began with the AAT, but as the slide says, the Act didn't mention or define what merits review was. Have a read of the extract from She and the Migration Agents Registration Authority in the textbook. It's certainly different from judicial review though, although if you read the Kane article that I've prescribed for additional reading, you'll see he argues that perhaps the distinction between merits review and judicial review isn't quite as sharp as it's usually argued, but it's nonetheless very different. Now, Justice Gary Downs, who was the president of the AAT until not that long ago, had this to say in Re Visa Cancellation Applicant and the Minister for Immigration and Citizenship in 2017. He stressed that tribunals need to look at what is good government administration, not just at individual justice for the individual applicant. So the correct or preferable decision doesn't mean just the preferable decision, the most just decision for the individual necessarily. It requires a balancing exercise. Justice Downs had this to say: the tribunal in its determinations must be informed by matters of good administration. It needs to be conscious that it is, in this case for example, contributing to the many decisions made within government which together determine how the population of Australia should be made up. None of this is to deny the very important role of the tribunal ensuring that individual justice is done, but ideals of individual justice do not, however, replace the demands of good administration. And he goes on to say, in trying to flesh out what correct and preferable decision means, which was first used in Drake's case, that I'll mention in a minute. He says, it is important to remember the difference between court adjudication and administrative decision making. Judges are not often called on to make decisions which require an evaluation of the consequence of a decision in terms of public interest. Their focus is more on questions of lawfulness of conduct. The power of administrative decision makers, both within government and on review, is often a significant power. in terms it can exceed the powers of courts. The extent of the power implies that it must be exercised with care. Administrative decision makers at all levels frequently make decisions which affect the operations of government where individuals are affected. Very often, the only clearly applicable measure or touchstone is the public interest. So how is the public interest to be determined? Well, Justice Downes goes on to confess that usually there'll be no sensible way of having evidence of what the public interest requires. It's going to be dependent on the assessment and evaluation of the individual tribunal member about what the public interest requires. At the same time, he says, that doesn't mean that you're just free to, as a tribunal member, to adopt your own subjective, idiosyncratic definition of what the public interest is. The requirement is that the tribunal member or members turn their minds in a careful, good faith manner to working out what the public interest requires in a particular case. And even though, that's not completely perfect, is it? Because, you can't pin it down with absolute precision. Downes argues that's still much better than just allowing for tribunal members to make their own subjective decisions of what is a fair thing. He says, drawing on these considerations, even without detailed analysis of them in reasons for decision, will lead to better formed judgments which more truly reflect community standards. An assessment expressed to be guided by community standards or values without more will still be likely to lead to better decision making than if no attempt at such an assessment is made. Expressing an opinion that current community standards require a particular outcome will be likely to represent a better decision than one couched in personal terms. Such an assessment will sometimes lend itself to reasons, but where there are no reasons, however, the decision and the basis for it will still be better expressed than with reasons couched in personal belief, because it's forcing the administrative decision maker to think and reflect on what the public interest requires, rather than just shoot from the hip and make an emotional decision on their first blush impression of what's a fair thing. And just a little bit more consideration of the conceptual aspects of administrative tribunals before we go on and look at some of the cats. The processes, as the slide says, are different to courts. There's a common statutory requirement you see in all of the general administrative tribunal statutes, that a tribunal is to provide a mechanism of review that is fair, just, economical, informal and quick, and to, quotes, act according to the substantial justice and the merits of the case. So say that's a general philosophical requirement, if you will, of both the AAT and all of the state tribunals. It's also, generally speaking, expressed as the distinction between an adversarial and an inquisitorial mode of operations. The distinction, though, between inquisitorial and adversarial is not as sharp as one might think, because it's certainly true, as the second dot point says, quoting Kaswadana and the Minister and Greenham, that tribunals can and often should examine issues outside those raised by the parties or by the decision under review, where there are issues about general broad good administration and consistency involved. And so in that sense, the tribunals are inquisitorial rather than adversarial. you can't take that too far. I mean, in an ordinary court of law, for instance, you have an adversarial situation where you have two sides, or sometimes more than two sides, and the judge takes generally a relatively passive role, refereeing the contest between the two sides and making up his or her mind on the evidence as it's presented before him or her. Tribunals can go further than that. They can demand that issues outside of those raised by the parties themselves need to be dealt with by the parties, or for that matter, issues, as I say, that aren't even raised directly by the decision, but go to broader issues of consistency or fairness across the board. So it's inquisitorial in that sense. But what tribunals can't do, largely for two reasons. Firstly, because they're not empowered to, but secondly, because they're not given resources to go out and find evidence for themselves. So unless the evidence it's obvious where to find it, it's published somewhere or something like that, it isn't feasible for a tribunal in exercise of its inquisitorial function to go out and find evidence for itself. So it's not like an anti-corruption commission, which does have the power to go out and find evidence for itself and does have investigative resources. The same goes, for instance, for the Ombudsman, even though the Ombudsman doesn't have very, very wide-ranging powers to implement any recommendation he makes, and we'll look at that next week. The Ombudsman typically does have very wide-ranging investigative resources and powers, almost like those of a Royal Commission. So an Ombudsman certainly is inquisitorial and is equipped with the powers to go out and conduct an inquisition, if you will. So does an anti-corruption commission or a royal commission, but administrative tribunals don't have those powers or resources. So in that sense, they're not really inquisitorial. They're much more like a court than they are like an anti-corruption commission or, for that matter, the Ombudsman. Now, the next point that's worth making, again, is on this slide. Unless it's specifically provided in the legislation, the expectation is that a tribunal looks at the matter anew, or de novo, to use the Latin expression, according to the facts and circumstances as at the date of review. Now, that means that if either the circumstance, the facts, or for that matter, the law have changed since the decision was first made by the designated administrative decision maker in the department or agency, the tribunal is required to look at it at the time the tribunal hears it. So that can make a big difference. If the facts have changed or the law has changed, the tribunal applies the facts and law as they apply at the date of the administrative tribunal hearing. Can make a huge difference. However, you should note ESBA in the Commonwealth, which draws a distinction between a change in the law that has to be applied with a situation where accrued rights that were accrued at the time of the application, or at the time the application was determined for the first time, are not diminished. Now, I won't go into that for the purposes of this lecture. We'll be looking at that in the tutorial on this topic, but just flag for present purposes ESBA and the Commonwealth and have a read of the material on that in the textbook. Now we come to the cats, the State and Territory Civil and Administrative Tribunal. Herding cats, I call it, with a very, very bad joke. They say you can't herd cats. I think that's probably right. Whether you can herd state-level administrative tribunals, I'm not sure. We only look here at VCAT, SACAT and NTCAT. I don't look at the New South Wales Civil and Administrative Tribunal. I don't look at the Western Australian one or the Queensland one. Tasmania doesn't have one at this point. Let's start with South Australia. As the slide says, merits review was originally, or general merits review was originally done by a division of the District Court of South Australia. And of course it can be in a state because there's no constitutionally mandated separation of judicial from executive power. So it's possible for merits review of executive decisions to be vested in a state court. And that's the way it was in South Australia until March 2015, when South Australia followed the model that had originally been set by Victoria with VCAT and New South Wales, which implemented something that was originally called the Administrative Decisions Tribunal before it went over to New South Wales CAT. It commenced operation in March 2015. Jurisdiction divided into three streams: community matters, housing matters, with a limit of damages of or award of $40,000. So that included disputes about residential tenancy agreements, retirement villages, residential parks, and rooming houses or boarding houses. Civil matters up to a fairly low limit. I should have checked what it was. I think it's $30,000 or thereabouts. Now you'll notice each of those first three dot points are judicial power, right? They're powers that can be vested without restriction in a court, could be vested in a federal court for that matter, because they're an exercise of judicial power, determining existing rights rather than conferring new rights and liabilities. So a substantial part of SACAT's jurisdiction is substitutes really for the civil jurisdiction that had previously been exercised by the South Australian District Court. But the fourth arm there, administrative law, merits review and disciplinary matters, is very much executive power. These were functions that are ones that are. Now something rather strange went on at the end of that last slide, but I won't worry about it. We'll carry on regardless. Now we come to Victoria, VCAT, the Victorian Civil and Administrative Tribunal. Now, as I mentioned on the last slide, Victoria was the first jurisdiction to implement this hybrid model of a tribunal that undertakes both merits review of executive decisions and undertakes a lower level judicial jurisdiction of determining small civil disputes, sometimes not necessarily all that small. VCAT has a human rights division as well, which is reflective of the fact that Victoria, along with the ACT, and now I think only very recently Queensland, has a human rights charter. Well, VCAT has an integral part in dealing with human rights issues under the Victorian Charter of Rights and Freedoms, I think it's called. VCAT also has a jurisdiction concerning matters relating to guardianship and administration, discrimination, privacy, and mental health. Now, all of those are also somewhat hybrid. Some of the functions are judicial, some of them are executive functions that could be and to some extent are conducted by executive bodies, the State Guardian and so on, Privacy Commissioner and so forth. Planning appeals it can do. Now, planning appeals are certainly an executive function because you're seeking new rights. So, you know, if you're an applicant, you're seeking a planning approval to enable you to construct some sort of a development, and therefore, you know, requiring a change of zoning or something like that. And in addition to all of those things, which are largely, as I say, but not entirely, administrative law merits review, VCAT also has a civil jurisdiction to adjudicate domestic building disputes, I think without limit. So VCAT can be adjudicating on claims for damages for domestic building involving hundreds of thousands of dollars, perhaps even millions of dollars in a small number of cases. So, you know, it's not a penny ante body, if you will, VCAT. Very significant jurisdiction. Lastly, we come to the Northern Territory. Last but certainly not least, the Northern Territory Civil and Administrative Tribunal, or NTCAT, commenced on the 1st of January 2015, absorbing the jurisdiction of 35 commissioners, tribunals, committees and boards. So it certainly streamlined merits review in the Northern Territory, perhaps to an even greater extent than in some of the states, because there's a greater need for it here in the Northern Territory. You know, we've only got 250,000 people, so you really do need to have an efficient, streamlined system of merits review. It makes sense in a lot of ways to have one polyglot general jurisdiction merits review body rather than 35 of them or something. But like the other CATs, NTCAT's jurisdiction includes a general administrative law merits review function, as I've just said, absorbing the jurisdiction of 35 merits review commissioners and tribunals and so on. But it also has a civil jurisdiction with judicial functions analogous to a local court, where, as I say, similarly with SACAT and VCAT, it makes final and binding decisions which may involve awarding damages or compensation. That being, of course, the definition of judicial power in cases like Huddett, Parker and Moorhead that we've traversed very briefly in topic 1. So the CATs are exercising both administrative law merits review function, which is an executive function, and also at a lower level exercising judicial power. So NTCAT is a very clear example of that. It has small claims jurisdiction, and small claims aren't all that small. Disputes up to $25,000 in value, generally speaking, must be litigated in NTCAT. If you try and commence them nowadays in the local court, it'll get compulsorily transferred to NTCAT in most cases, except in very exceptional situations. NTCAT also determines all residential tenancy disputes. It also determines unit or strata title disputes between owners and body corporate. And again, like VCAT, it deals with applications for guardianship orders for people with intellectual disabilities, and it also deals with disputes involving complaints of discrimination, where the Anti-Discrimination Commissioner has to deal with them first and try to deal with them by mediation or conciliation. But if that fails, it has to be determined by NTCAT. So again, NTCAT is a very significant body in the hierarchy of courts and tribunals in the Northern Territory, fulfilling